in advance that it's very hard in family law to give bright line rules and bright line answers because the fact specificity of the inquiry really is what leads decisions. But we do want to communicate, our hope is today that we're going to be helping folks to understand the general principles and information about how processes are working in the probate and family court, so that there's some more guidance for people working in family law to be figuring out sort of what the new rules are and new considerations. And so on that note, first of all, I wanted to tell everyone that we are recording this. And the reason that that's important is if people in the Q&A want to ask questions about clients, we just want you to sort of be aware that this session is being recorded. So we're going to start, we're honored to have Kristen Wiggin with us, who's going to be talking to us what we've called her talk, The State of the Courts. So describing for us sort of what's happening in the court system and factors people should be taking into consideration. Kristen has been in private practice for 23 years and an attorney for 28. For the past 5 years, she's been with the trial courts of Massachusetts at the Court Service Center, and she's currently the manager of the Court Service Center in Lawrence, Massachusetts. So I'm gonna turn it over to Kristen to kind of walk us through the unenviable job of explaining sort of all of these standing orders and what they all mean.
Thank you, Naomi. I just wanted to thank you and thank the panel for allowing me to speak today. It definitely is a moving target as far as how the courts are operating. But I'm pleased to present today, and thank you for all the participants as well and the people that are logged on watching. So the good news is that the court is open, and it has been open virtually. And the court will continue to be open to conduct emergency and non-emergency business in both the civil and criminal arena. What's closed is the court buildings. They're physically closed to the public, and all business right now is being conducted virtually by either telephone, video conference, email, or any other comparable means, or through electronic filing system. And that's going to be in place until July 1st. There is an exception to that, and that if there's an emergency matter which cannot be conducted virtually, then conceivably there could be an in-courthouse hearing. I have a slide presentation that is pretty comprehensive and maybe goes beyond. I'm going to share the screen just a sec. Can everybody see it? I have a slide presentation which I will go through, but I won't go through each slide, because I think that you can, after this is over, you can take a look at it and see if there's anything else that might help you. But I will touch upon the highlights. So people want to know when the courthouse is going to be open to the public. Sorry, I'm getting these admitting to admit people, and sorry, let me just, okay. So when is the court going to be open to the public? So the Supreme Court Justice Chief Gantz stated in a court order recently, as of yesterday, which becomes effective becomes effective June 1st, that courthouses will only be open to the public once there's protocols in place that will allow court users and court personnel to feel safe and to be safe. There was some discussion about courts opening over the summer, but the most recent court order is talking about just a general provision that people have to be safe and in the courthouse for it to open. And that when the courthouse does open, it will happen in stages. So it will be, a slow opening of different aspects of the court, and that the court will first address matters that couldn't have been handled virtually, because right now, matters are just being handled virtually. So the newest court order from the SJC talked about jury trials and bench trials and when they may resume, and you can take a look at that later. There's district court matters that are by court order or standing orders have been dictated to be emergencies, which is, one of them is, of course, emergency abuse prevention orders, harassment orders, Section 35 hearings for substance abuse, and mental health hearings, among other emergency matters. So that this list is just relative to civil actions only, but that is open for virtual hearings, of course. Then, of course, there's non-emergency matters. And what I really wanted to focus on, which I think may be important for the people that are attending this Q&A, is the procedures that are in place to contact the district court. And then I'll also go through the probate court as well, but we'll start with the district court. So if you're filing or you're helping somebody file a restraining order or a harassment order in the district court, you can certainly call the courthouse, which is different in the past. In the past, we physically went to the courthouse because calling, but they're encouraging everybody to call. So call the courthouse, and the way you would find the phone number, I put some websites up here, but you can log on to the courthouse locator website, which will give you phone numbers and emails. Or if you're just looking for email, there's a link for just emails of the courthouses. And I believe that link actually gives you all of the emails for each trial court department, including district and probate and family. So what you need to do is call the courthouse first. That's what they're encouraging you to do. Or if you can prepare your pleadings, your paperwork ahead of time, then you should definitely email the court and put emergency in the subject line. In addition to that, you can always physically go to the courthouse and drop off your documents at the front door, as long as it's safe to do so. And of course, US mail is always an option, but it's probably not practical in an emergency situation. But the clerk's offices are regularly going to the front door to collect documents that have been dropped off. So that's an option for people that may not be able to send something through an email, or for whatever reason don't have reliable telephone service. On April 2nd, the trial court established a helpline, which is a phone number that is available as a backup to the clerk's offices, each individual clerk's offices, and the phone number is there. It's 833-91-COURT. So that is staffed by people from all different divisions or departments throughout the court, and they can direct you to a knowledgeable person. And of course, something that was always available is www.masscourts.org, and that's available to the public that you can look up cases. You wouldn't be able to find restraining orders or harassment orders, but other matters can be found there as well. So Probate and Family Court has also delineated several emergency type cases, of course, restraining orders being one of them. So you can seek jurisdiction in a Probate and Family Court, as well as the district court, to file a 209A request. And I'm not going to go through them, but there's several matters here which are classified as emergencies. And there's also non-emergency matters, which the court is now attempting, or the court is attempting to hear non-emergency matters, so long as they can be heard virtually. Now, I just wanted to talk about court forms, because as a result of COVID-19, the court has developed certain court forms which are savable. Of particular use, of course, is the abuse prevention order forms. There is an explanation page, a complaint page, an affidavit, defendant's information, plaintiff's information. It's all contained in one form, and they have the same for the harassment orders. It's going to be the complaint, the affidavit, and the defendant's and plaintiff's information. It's all contained in one form. So if you're just looking for a court form in general, the link is right there at the top. If you're looking for those particular fillable, savable forms, there's a link in the middle there for those forms. So you may want, particularly with probate and family, if you're filing abuse prevention order in probate and family, you may want to call the court to Ask if there is any additional forms. So for example, if there's children involved, probate and family court requires an affidavit disclosing care and custody. In the courts where I work, probate and family court has a cover sheet for abuse prevention orders. And one thing you should know is if you're using those fillable and savable court forms, you need to, once you fill them out, you need to save them, because if you attempt to email it without saving it onto a desktop, it's not going to keep your information in that form. One other thing that I've found as I've been helping people through the Court Service Center is that Adobe Acrobat Reader DC has a free feature called Fill and Sign. So if there's any forms that are not fillable, for example, as I mentioned, there was a cover sheet for probate and family. If they're not fillable, you can go into that Fill and Sign feature. You open up your document through Adobe Acrobat Reader, click the Fill and Sign, and you can click into parts of a form and fill it out and save that as well. And that will help in case a litigant doesn't have a printer, or is able only to just save the forms and email them rather than print them out. But just remember, they need to be saved. So I think that's pretty helpful in this circumstance. The other issue is, when you're filling out restraining orders or harassment order petitions, it needs a signature. So there's as of April, the SJC authorized the use of electronic signatures. So just either it can be a scan of a handwritten signature, or number 2, you can use the \S/ and the type name, which would constitute a signature. And it says that if an affidavit is signed under the court order says if an affidavit is signed under the penalties and pains of perjury, and you are unable to obtain the scanned signature or original signature, then you can still submit it electronically with the \S, but you're supposed to, or you should, take steps. It says you must actually take steps to secure the original signature as soon as possible and mail that in. So one other issue, of course, a big issue is language access. If you have a person that you're assisting that has a language access issue, best thing to do, again, just like when we're talking about contacting the courts, is to make sure that you call the clerk's office. And I always prefer an email follow-up with the relevant case information, the hearing date, as much information as you have, and letting them know as quickly as possible the language that you need, and they will make an interpreter available for the hearing. So some people signing up for, while they were signing up for this program, were interested in knowing how to have, say, witnesses or documents, quote unquote, attend the hearing. So what you can do again is call the clerk's office, email the clerk's office, give them that information. They will make arrangements and work with you to have witnesses to be present. Documents, if you have a document, like screenshots or pictures that you want to submit during a hearing, you can get the document and either scan it in and email it to the court. Again, you can drop it off at the court with some, a label saying that what it's for if you're not able to email it over to the court. You can be very creative with getting these documents to court. And really you're encouraged to call the court or email the court for those email addresses that are listed online for the court. So another question is what to do if the court user lacks reliable communication devices. So, and I've had this issue while assisting litigants where they don't have a reliable telephone, or they don't have a computer or a printer. The guiding orders and even the most recent order has dictated that there are exceptions to the requirement of virtual court hearings in the court right now. And so if you make known in some way by either a call, or if you're able to use somebody's email or have somebody email for you and let them know that you're not able to do a virtual hearing for whatever reason, the court can accommodate you based on a showing of exceptional circumstances, and certainly not having the ability to communicate through this virtual device would be an exceptional circumstance. I just wanted to talk about resources, and I know Rochelle is going to talk about some other resources, but just from our end, as you heard in the beginning, I am the manager of the Court Service Center in Lawrence, but we have court service centers that are physically located in multiplex courthouses in Boston, Brockton, Greenfield, Lowell, Lawrence, Springfield, and Worcester, and we're all operating remotely in some shape or form. We are also, like the courts, in the process of getting up to speed in terms of having a video ability and sort of a global helping system. But the best way to get the assistance of a court service center is when you call your local court. When you talk to the clerk or the registrar's office, you can ask them, do you have a phone number for the court service center? And those, and then they can then refer you to one of our centers for assistance. And we help draft, we have certain limited cases that we're working on now, but we do help draft restraining orders or abuse prevention orders, harassment orders, and other emergency proceedings or pleadings that we can help with. So there's the Lawyer for the Day programs. Some of them are also working virtually. I'm going to talk a little bit about how that's going to work with the registries in just a second. There's law libraries. This has always been available, which they have a chat resource online. So you can look up a local law library and be connected with a librarian in the law library who can help you research and give you also appropriate forms that you may need. And of course, there's legal service agencies that have set up hotlines and are able to help people remotely as well. So I just wanted to talk very briefly. I'm sorry, I'm going to go back to the procedures for contacting probate and family, because I skipped that, I think. I apologize. So again, for contacting probate and family court about your emergency matter, again, same as district court, you can email, you can call the trial court helpline. You also have access to masscourts.org, which has a lot of different family case law types that you can take a look at on masscourts.org. But there's also a pilot program, a virtual registry that is being piloted in Essex, Barnstable, and Middlesex. The virtual registry is very helpful. I tried it myself. It's a link that's online. I've only found the Essex link. I haven't been able to see Barnstable or Middlesex yet, but you literally click on that link. It's available from 8 to 4:30, and you go face to face with a person who's sitting at a desk, and you can get all the same services through the virtual registry that you could have gotten if you were physically standing in line at the registry's office. And so I've tried that out with the Essex County, and then what they do from there is they talk with you about your situation. They can exchange documents between this virtual link through Zoom, and they can give you pleadings. You can file anything that doesn't require a fee through this virtual registry, and they can send you to what they call a breakout room, where you can actually have a discussion with a assistant judicial case manager or the office manager or another clerk that may work, or a clerk that may work in the registrar's office. So it's a pretty neat feature, and the courts are going to be using, or the courts, all the judges have their licenses for Zoom as well. So the courts, it's in conjunction with the courts that this is going to be a system that we want to get people used to through both using it through this virtual registry, and ultimately there will be court hearings that will be occurring that way. So just as a final thing, I just wanted to talk to you about what a hearing looks like. As I said, I've been working on a hotline for the Court Service Center. What will happen is a court user or litigant will call the clerk's office, or they may contact their local police or a domestic violence agency, and they have our information. They then make a referral to the Court Service Center. We then assist in preparation of all the pleadings, the complaint, the affidavit, and so forth. We then email it to the court, and we send a copy to the court user. once the court receives that information, the court then contacts the court. So the clerk's office or the registrar's office will contact the court user, and they will provide them with an 800 number and an access code and a specific date and time to call. So it's incumbent then upon the court user, the plaintiff, to make the phone call at that time, and they will be connected with the courtroom clerk and judge. And so at that hearing, there will be a judge and there will be a clerk. And the initial hearing, ex parte hearing, which means without notice to the other side, the defendant, the court will give a 10-day order and then a return date once the defendant is notified, which the defendant is usually, they try to notify him right away or her right away. And they will give a return date where there will be the same procedure. You're going to call in, you're going to have an access number, and that will be, and then there'll be a hearing in the same way, except that the other person may potentially, the defendant may potentially be on the phone line. And at that point, the orders can be granted for up to a year. And then if a person disagrees with that order, they can motion the court for an in-person hearing at a later date. So I think that pretty much covers what I was going to speak about. I don't know if there's any additional questions or information, Rochelle or Naomi? No?
No.
It was very quick, but I was trying to look at the time.
Thank you so much for giving us all that information. That is a tremendous amount of information to share with us, and we really appreciate it. And I just want to let everybody know not to panic, that we're going to get the video and the slides emailed afterwards, so you can go back through if you need to revisit any of the things that we talked about already. I just want to say quickly, acknowledge quickly that there are so many unknowns about what's happening right now, about just about everything, but there are some things that we do know, particularly as it relates to domestic violence. We know, according to Safelink, that their calls are down 15%. And even though there's some variation across the state, we know that Boston saw a 22% increase in domestic violence, simple assaults during the course of this pandemic that we have now. We know that isolation is a powerful tool used by perpetrators even under normal times, and basically this tool is essentially nuclear during this pandemic. We know that many of the routines that survivors count on to give them a moment of peace and safety, like going to the grocery store, dropping the kids off at school, going for regular doctor's visits and counseling sessions, all those routines have been interrupted. And it goes without saying that the stay-at-home advisories mean that entire households are forced to share space with little privacy or respite, and that access to usual friends and family who are sources of support and help is probably also extremely limited. Many of the key resources that help survivors live and plan on a daily basis are closed down or extremely limited or remote. It was really exciting to see how many different community members were dialed in for this call, because we all know that survivors reach out to lots of different places to get the support that they need. So as survivors weigh their options right now and balance out the risks that they have in front of them, we of course need to keep remembering that safety planning is so individual and involves a lot of creative thinking, especially right now. We're going to turn right now to talk about a couple of those tools that are available, and particularly how they've been impacted by the COVID-19 crisis that we have. And I'm excited to introduce you to two amazing panelists right now. The first is Jessie Aquino from MOVA. Jessie has 17 years of experience within the domestic and sexual assault field. Before joining MOVA as the Senior Victim Service Manager, she was the civilian police advocate providing advocacy to survivors navigating the criminal justice system. She has experience as a safe plan advocate in Hampshire and Franklin counties and co-facilitates the sexual assault curriculum at the Western Massachusetts Police Academy. Jessie holds a bachelor's degree in criminal justice from the University of Massachusetts Amherst and a Master of Criminal Justice with a focus on gender-based violence from Boston University. And we also are lucky to have with us today Jamie Ann Sabino, who wanted me to introduce her as the Mass Law Reform staff attorney focusing on domestic violence and family law. But many of us know her as just an overall guru of anything related to domestic violence and family law. So thank you both for joining us today. Jesse is going to start off by giving us some information about accessing 209As and 258Es in district court, and then Jamie is going to follow up with some discussion or some information about how that access might differ a little bit in the family court and the Boston Municipal Courts. So thank you, everybody.
Thank you so much, Jen. So hi, I'm Jessie Aquino. I am the Senior Victim Services Manager at the Massachusetts Office for Victim Assistance. I oversee the SAFE Plan program for MOVA. So SAFE Plan is MOVA's statewide court-based advocacy program. SAFE Plan provides specially trained advocates to help victims of domestic violence, sexual assault, and stalking who are seeking protection from abuse. And so I'll give you a quick overview of the restraining order and harassment protection orders that we have in Massachusetts. So there are two types of protective orders that a victim could request when they're seeking relief from the courts. The first is the Mass General Law 209A, also known as a restraining order. It's intended to provide survivors of domestic violence, sexual assault, and stalking a civil protection against someone who the victim has a specific relationship to, so either by blood or marriage, dating, or maybe they have a child in common. This is a civil order, but it will trigger criminal consequences if the order is violated. Protections under a 209A order include a no abuse provision, a no contact provision, a stay away from the residence, workplace, and or school, as well as some protections regarding minor children of the plaintiff if they have been added to that order. If a 209A is issued, it will order the defendant to surrender any guns, ammunition, and licenses to carry. This protection is super important because just the presence of having a firearm in a domestic violence situation seriously raises the chances of lethality. The second order that we'll talk about is the Mass General Law 258E, and that's commonly known as the Harassment Prevention Order. This order was created to protect victims against someone who is harassing, stalking, or sexually assaulting them. So a victim is able to request this type of order, protection order, if they don't have a relationship, or even if they don't have a relationship to the defendant, the perpetrator, the abuser. So for example, a boss, a landlord, a stranger. This order, it offers very similar reliefs to that of the 209A order. However, the 258U order doesn't require the defendant to surrender their firearms, ammunitions, or license to carry. So we had some questions come in, and one of them was obtaining an order during the COVID-19 pandemic. And so I'm gonna talk, and Jamie's with me, I'm gonna talk briefly about what things look like in the district court, and then and if you want to add anything in there, Jamie, you can totally jump in whenever you want. But I'm going to talk about the district court, and so during the COVID-19 pandemic, the restraining orders and harassment orders are still being processed. These requests are considered emergency matters. So a 209A and a 258 forms, those forms have been made available online on mass.gov. They've been made available as fillable forms, as Kristen had mentioned earlier. These forms can be completed online and then submitted to the court. A printer isn't needed because they can be submitted electronically. But each district court and probate and family court is functioning slightly differently due to operating with a reduced and staggered staff. So it's highly recommended that the victims seeking protective orders contact the court in their jurisdiction to be informed of that court's specific process. Generally, however, the process is as follows. So orders requested during normal business hours, that would be Monday through Friday, 8:30 to 4:30, they are to be heard by the court with jurisdiction over the matter by the judge presiding that day, and will be heard by either video conference or telephonic conference. And I think currently we're doing telephonic, but I'm sure that they're moving into the video conferencing part, with the parties not being present in the courthouse. Paperwork is filed with the court either by mail, fax, email, fax, or the clerk taking the information from the victim and filling out the appropriate forms. Requesting an emergency protective order after normal business hours, that would be after 4:30 in the afternoon on Saturdays or Sundays or a holiday. Those occur at the police department, and that triggers the emergency judicial response. So orders sought through the emergency judicial response system are valid until the next business day, but they can also be treated as ex parte orders and issued for 10 days at the discretion of the judge who hears the matter at that moment. Somebody wanted to know what happens to orders, extending them and changing the existing orders. So extension hearings for restraining orders are being conducted by video conference or teleconferencing. Generally, the court is calling both the plaintiff and the defendant the day before the extension, and providing a conference number and password for the hearing. The plaintiff must attend the extension hearing for the possibility of extending the order. Otherwise, it'll expire by the operation of law. Modifying a restraining order requires the plaintiff to file a motion with the court. Expiring orders while the courts are closed. So all emergency protection orders issued after notice prior to March 18th, 2020, and that are due to expire on or after March 18th, 2020, shall remain in effect until the matter is rescheduled and heard by the court. Any orders issued prior to March 18th with a hearing scheduled during the pendency of this order are to remain in full force and effect until the matter is rescheduled and heard by the court, unless an order issues by the court terminating the order at an earlier date. And any protection orders issued at a hearing after notice during the pendency of this order, which was not heard in person, but may be issued only until such a date as which the court can reschedule an in-person hearing, or at this moment, a telephonic hearing. How is a defendant being given notice of the initial order or any subsequent orders? So after the initial hearing and an ex parte order issues, law enforcement is responsible for serving the restraining order. Service is usually conducted initially in hand to the defendant, but this has changed for some towns and cities during the COVID-19 pandemic. So for instance, a place, Brockton, the Brockton area, the Brockton Police Department has been serving restraining orders by leaving a copy of the order of the defendant's order at their residence, because they have a large volume of people that they see. It is recommended, however, that the plaintiff confirm with an advocate, with the clerk, or the defendant's law enforcement department on how the restraining orders are being served. And we highly encourage people to contact the police department and ask if that order has been served, and request that they get notified when the order gets served. Does the plaintiff have to face their abuser in court? What does it look like now with the telephonic or video hearings? So that was one of the questions. The defendant has the opportunity to attend the hearing after notice and any subsequent hearings. The defendant is not required to attend these hearings for the order to extend beyond the 10-day hearing date, provided the defendant has been served by the police department. The plaintiff's presence is required at any scheduled hearing to request a further extension of the order. If the defendant is present, both parties will have the opportunity to present testimony to the court. The format of the hearing is very similar to the in-person hearing. The judge will take testimonies from the plaintiff and the defendant and allow each to present evidence, and the judge may ask some follow-up questions during this hearing. So another question was challenges in requesting an order of protection and how to overcome those. There's always challenges when you're working through the court system, but some courts are having the judicial clerk magistrate screening survivors before filling out the paperwork that needs to be heard by the judge. The screening process is entirely at the discretion of the clerk magistrate. So victims who are in crisis and or are unfamiliar with the criteria for an order may tell a clerk magistrate information that may result in them being screened out, when in fact their situation may warrant them to be screened in. If a victim is screened out, you can imagine how that goes down? Well, it results in a lot of different feelings, you know, they feel like they're not being believed and may even feel more unsafe. This can prompt a victim to choose not to report to law enforcement, not to seek additional help through the courts, and even maybe not even seek access through other victim service agencies. To overcome these challenges, I think it's really important that survivors speak to an advocate that is knowledgeable in the criteria for the order of how to get a protective order. Having this conversation beforehand can ensure that the victims are relaying the proper information when they're speaking to the clerk magistrate, and they have a better understanding of the process. How can an advocate support survivors through this current process? So advocates can support survivors through the current process by talking with them about their options around obtaining a protective order and assessing their immediate safety needs. Individual safety planning is important when considering an order. We know this since forever. So supporting survivors remotely includes additional steps to ensure safety and confidentiality. Support can begin by making sure the victim is safe to speak, asking if they have any injuries and if they need medical attention, and listening for indicators of abuse and trauma that can't be seen over the phone. For instance, when assisting a survivor in person, an advocate may be able to recognize signs of concussions. This may not be as easy over the phone. Advocates must now assess potential injuries sustained to a survivor by asking them questions based on the assault described and disclosures made by the survivor. And will judges, courts allow advocates to assist with the forms or attend the hearings? So just like Kristen had said before, the forms are all online. If there are some missing, people can call the courts and request them, but the forms are online, making them accessible to the survivors and the advocates. Advocates helping with the paperwork takes a huge burden off of the survivor, which helps the survivor focus mainly on the affidavit piece of the paperwork, which is a really important portion of the order. Courts have generally been accepting the advocates submitting paperwork on survivors on behalf of, the courts have been accepting the paperwork that the advocates are submitting on behalf of the survivors. And they're encouraged to work with court staff. In addition, judges have definitely allowed advocates into telephonic hearings with the condition that they mute their audio. And that's important because the victim can feel supportive. Safe plan advocates, even when we didn't have a pandemic, they're not in the business of speaking up for a survivor. They usually just stand there and support them. So being there on the phone with someone offers a good amount of support. And then after the order or the hearing is done, advocates can follow up with the survivor and they do safety planning with them. They review the judge's order, they make further referrals to the domestic violence and rape crisis organizations and just make sure that they keep the person in the loop so that they could continue to access all of the services that they need. And that ends my piece for the district court section of the work.
Thank you, Jessie. I'll follow up with BMC and Probate and Family Court, but actually there's like a question that came in that I think really relates to the advocate. Somebody asks us, what if the person needs a restraining order against someone who they live with? That's a critical time where they need to reach out for an advocate because they will have to figure out how they can contact the court remotely, how they can have a hearing remotely, and where they stay until the order is served. You know, in the old days, 2 months ago, you go to court, you get your ex parte order, and then maybe you went to a girlfriend's house or hung out at the library all day till the police served the order if the person was being ordered to vacate the home. That is all much more challenging now. So you really need to reach out to an advocate, and we're going to be sharing a resource list that's also on the court website, which has not only the safe plan advocates, but all sorts of community DV advocates, particularly in counties that don't have specific safe plan advocates. It may be really difficult to just make that call if you're living with somebody. And so it's much more challenging. As to getting orders in the court, I did remind people that in the district court, although there are some differences based on, courts, there's pretty much uniformity. There's a court order that really covers this. If you are emailing papers to a court, call the court first. You have to call the court because this whole new email stuff is new and they're worried that things will get missed. So always call the court first. The differences in, and then one other thing is if your client can't fill out those forms, can't have access to it, or you're not a DV advocate, you're just supporting them in other ways, a person can also call, and in all of the district court offices, somebody will talk to you on the phone and they will fill out the paperwork for you the way a police officer does if it's an overnight order. So they're trying to make as many avenues open as possible. This is pretty much the same in Boston Municipal Court, but it's the difference in Boston Municipal Court. And for those of you who may not know, there are, I can't remember now, 1, 2, 3, 4, 5, 6, 7, I think there are 8 courts that are mostly in parts of Boston that are a separate court department than the district court. The cases are the same, they generally handle things the same, but their order is not quite as encompassing as the district court order. It basically says, call the court because they're all handling it differently. Even in the last week, this has changed. Most of the courts previously, you had to call them, but most of the courts I called this morning said that you could also email the forms to them. So one court insisted, no, we email the form to you and you email it back. And one court, which court is it? I'm sorry. East Boston Municipal Court requires you to come to the court. And a court officer will give you the papers and you'll fill them out, maybe in the lobby, maybe outside, and hand them back. They won't do it over the phone and they won't take anything emailed. So again, you need to always call a court ahead of time. Probate and family court, again, is fairly different. A couple of the courts said, yeah, you can email us or you could call. Some of the courts, it was difficult. One court had a list on the telephone thing, press 1 for this and press 2 for that. None of it was restraining orders. So if it's a divorce or paternity or probate, none of it said restraining orders, and took a while to figure that out. Mm-hmm. One court, Hamden Probate Court, says, well, we have the person call the safe plan advocate. So they give them that number and they tell them first. So they sort of, when I pushed them, said, well, if you wanted to send us the papers, we'd take them. One court said that, no, we don't accept restraining orders. This is a probate and family court. You have to call the DA victim witness advocate. It's a county that doesn't have safe plan, and the district attorneys, victim witness advocates help you fill out the forms, but those advocates don't have confidentiality. And when I told her if I didn't want to talk to them, can't I just send it to you? I said, no, you can't file 209 restraining orders with the court. We don't handle that. They're all processed through the district attorney's office. Clearly that's all wrong, but it gives you a sense of sometimes how difficult it might be for your clients even to figure out what's going on. 2 other things. Somebody had asked if virtual hearings are going to be a standard in the future, even after the pandemic. We don't know. We are hoping that it will be an option because for some people it's very difficult for them to get to court. For other things, you want to be in the court, you want the judge to see you. There's a lot of concern about judges being able to really assess people when they're in a little screen. But we just don't know what that's going to happen. There's been some questions about defendants. As was noted, the defendant is served with a complaint. If you're working with somebody who has had a 209A filed against them, and that may well happen, there are many cases where the abuser wins the race to the courthouse and it's really the victim who's the defendant, or maybe you're working with a broader population. They only get the complaint. And in the old days, 2 months ago, they could go to the court and read the affidavit even that morning. Now, if you're working with somebody who's a defendant, they should contact the court, and the court can email them the affidavit, or at the beginning of the hearing, the court can read them the affidavit. I just, again, want to really emphasize that not only are things different between many courts, but they keep changing. So calling the court, and in most of the courts, the people really want to try to help you, and they're really responsive. And I want to give a shout out to the Administrative Office of the District Court and Katie Fabry, the trial court domestic violence coordinator, who came up in a very short time frame with these fillable forms and have really changed the face of this terrible time for people getting restraining orders. I'm going to stop there, and I am available for questions in the future. And there's some people ask some very specific questions, like about getting a 209A against your child. I'm going to respond to those people individually outside of this presentation.
Thank you so much, Jamie. We really appreciate it. And the next segment of our program, we're very excited to have two more superstars in addition to the ones that have already presented. We have a joint presentation by Simone Bowie, who's the managing attorney of the Legal Aid and Representation Program at the Asian Task Force Against Domestic Violence, which is a multidisciplinary organization working with APIA immigrant communities. And then Cindy Palmquist, who is the legal director at the Volunteer Lawyers Project and has been there for about 5 years. And previously, she was a solo practitioner with a small private practice where she represented clients in family law matters, including domestic violence issues. And Simone and Cindy have taken a lot of time to really go through all the questions that folks had in advance of today and to really divide and conquer the main questions that people had. And so they'll be doing a series of presentations, one after the other, addressing some of the key substantive family law issues. So go ahead.
Thank you. I'm going to just give you a little bit of an overview as to how we've divided up the presentation. First, we're going to start with Simone, who will give you a foundation in domestic violence and the impact on survivors with and without children. Next, we're going to talk about how you can start a new case during the time of COVID, custody and parenting time. We'll talk about some general principles for all family concerns, whether they're domestic violence or non-domestic violence cases, and what parents can do. And we'll talk about modifications and contempts. What we tried to do was to take the questions that had been given in advance and work them into a presentation based on topic, so that we're hoping to get to the questions in a more natural way. There's also, Naomi will be moderating the chat, and if there are some specific questions that we haven't addressed, we'll try to do that as well.
Thanks, Cindy. So before I jump into the DV section, how DV impacts family law section, I just wanted to address some of the questions that came up from the registrants around language access and how advocates can help work with their limited English proficient clients and help them address language access issue or language justice issue. So I'm starting here because really this issue applies to legal remedies in all the courthouses and pretty much all legal remedies. And it's about doing our part or understanding our role in understanding that language is really a tool that can either be used to exclude or it can be used as a tool to empower and help folks exercise their legal rights in court and to pursue their due process rights. So prioritizing language access, for example, in my practice really is important to ensure that marginalized groups and especially survivors within marginalized groups are not denied equal access to the courts, to the court system, to legal protections. So I just a reminder that that LEPs, limited English proficient speakers, have a constitutional right to language access to courts. Courts are legally required to provide language interpreters for hearings if they're requested. So
my role, I see our roles as providers is it's really important to assess whether a party needs a language interpreter. We often work with folks who speak limited English, or maybe we think they speak moderate English, and we can communicate with them somewhat sufficiently outside of the court process or outside of the courtroom. But of course, that's very different than what happens within a court hearing, especially over the phone. Like over the phone is very, very, very difficult for someone who is even moderate English speaker to understand what's happening, or, you know, judges are speaking very quickly. Opposing counsel, if they're there, uses jargon. It can be extremely confusing, even for a native English speaker, let alone someone who's limited to moderate English speaking, to try to understand what's happening at breakneck speed over the phone. So just to, again, reemphasize, Chris Wiggin had a slide on how to request interpreters. You know, you can refer back to that, email the court, or call the court with the information on the case and the hearing date in advance. And I cannot specify enough how important it is to call in advance as much as possible, or to email in advance as much as possible, especially because many of the courts don't have, you know, they work with freelance interpreters, essentially, folks who live around the state that they have to coordinate with to see if that language is available and to get them on the call for the hearing. So just wanted to discuss that and answer that question. Okay, so getting into the DV impact on survivors around family law issues. And Jen Howard had mentioned some really important issues that we're seeing with survivors during this pandemic. I just want to do a really quick rundown of issues we're seeing related to family law that can impact custody or issues that arise in probate court. So we know a lot of folks are sheltering in place with abusers. Obviously, there's increased opportunities to control parenting decisions, homeschooling, social contacts, a lot more opportunities to exploit vulnerability such as immigration status, to monitor technology and text messages or emails, and a lot of opportunities to oppress or coerce a variety of issues around issues that will be related to probate court or family law down the road. So we also are hearing questions about fears of victims calling the police to protect themselves and children. And I'll also say in specific for APIA, Asian Pacific Islander American communities right now, we have heard stories from clients who are afraid to call the police or afraid to go and get medical assistance because of this fear of being blamed or berated for causing coronavirus, right? At a time when we're seeing everywhere sort of a rise in physical attacks. So that is something we want to keep in mind. The other thing is that there's a fear to call the police or seek protection for themselves and their children. So just because someone isn't calling 911 or isn't seeking a 209A doesn't mean that there isn't violence going on at the time. We are seeing folks who are afraid to call the police, knowing that if the police doesn't arrest the abuser or the 209A is not extended beyond the 10 days, that the abuser returns home. And the victim may not be able to access a DV shelter or have income to rent a new apartment or something like that. I've spoken to clients who said they've chosen not to call the police if there's no guarantee that the police will arrest the abuser. So safety planning around these issues is extremely important because all of these issues, DV issues, you know, happening in families with children really does impact the family law issues that kind of come down the road and custody and care issues that sort of follow the DV issues once the victim separates from the abuser. And wanted to also just, someone had a question about domestic violence shelters being open for victims to move into during this time, and that DV shelters being a place that they could have moved into. You know, if you're going to call 911 or your safety planning with your advocate, with your client, your DV advocate, the DV shelter was an option. Whether they're open, that really is a case-by-case basis. Some are open, some are not. I think it's important to call Safelink if you need language access for Asian clients, call ATASK, but to call Safelink. And also if they're already working with DTA or DCF, there's a case open, they can hopefully coordinate with helping to find temporary safe shelters if there's children involved as well. And also the other thing that DV advocates can do in addition to safety planning is referrals, and to work sort of in an interdisciplinary way with attorneys to kind of do what's necessary for the victim and their children. And I think the next section, before we get into additional sort of substantive family law issues, Cindy will be talking about new cases, filing new cases.
So a couple of people asked questions about whether someone can start a new case. Yes, you can absolutely start a new case. The court is trying to make sure that people are aware that the courts are open for business. The physical courthouses may be closed to the public for the most part, but again, they are accepting new cases. The problem is how you file the case. It depends on where the case is going to be filed. One of the things about having a system that is based on counties is that there is a lot of autonomy amongst the individual counties, and what that can mean is that the registries are doing things differently in every county. But you can absolutely start a new case, and in many circumstances you would want to start a new case as soon as possible, even if it's not an emergency, but let's say it's a child support modification. You'd want to file that modification as soon as possible because the order can only be modified from when the complaint for modification is filed and served. Can only go back to that date. Many clients are used to filing cases in person, and that is not as much of a good option now. It might be a question of how they could get to the courthouse. Even if the courthouse was allowing you to leave documents at the door and they were accepting them, the question is, how safe are they? How long are they standing there? What's happening to those documents? There's a lot of questions about that, and I don't think that it's uniformly practiced that all of the courthouses are going to accept pleadings that way. Some will accept them by email, some will not. I really wish that we could give you a clear indication, but we can't, and that's why we're emphasizing over and over how important it is to call the courthouse. Another question that came up was whether you can, if there's certain types of cases that the court is not accepting. No, the court is accepting new pleadings. However, they may not schedule a hearing right away unless what you're filing is filed as an emergency. Another question was whether someone can get a temporary order. Temporary orders are not likely to be scheduled or heard right now unless it's an emergency temporary order. There's going to be a link that is shared about what resources are available to litigants, and also some of the information that's available on the courthouse. There's a section on the court's website on mass.gov/courts where they list the operating procedures for each individual county, and it will there have what the phone number is, what they're considering emergencies, what types of cases they're accepting, whether there's a specific email address they want you to use, etc. So yes, you can file a new case. How the case gets filed, that's a harder question to be able to answer. Next one, we'll be talking about custody and parenting time.
For shared parenting time, shared custody, first, I just wanted to answer a couple of questions around supervision centers. Someone had asked a question about supervision centers being closed during this time and what to do. They are closed, of course. I am not aware, unless someone else on the panel is aware, I'm not aware of any supervision center holding or hosting sort of a supervised virtual visit themselves. I think, if
there is one.
Oh, there is one?
Yeah. Pat Kelleher, the South Shore, I'll get the contact and put it in the chat. But
Okay.
That's the only one I know of.
Great, thanks, Jamie. Should have asked you, Jamie. So it sounds like there's one. It's probably limited, and that might be changing as the reopening phases start to change as well. But right now, it's still limited. So for those families that are being impacted, instead, we're hearing about abusers demanding unsupervised visits in lieu of the supervised visits. Of course, that's not something that a victim would have to agree to. You could coordinate virtual FaceTime visits if possible. Try to cooperate. Try to coordinate that in writing through email or through text. And especially if one of the parents is a survivor, in that situation, definitely try to communicate through writing, but also try to work with a DV advocate to help safety plan on how to set up those virtual visits where the abuser would be looking into the home. Also, another question came up around the status of guardian ad litem investigations on existing cases in probate court. The latest, it was extended initially, and the latest extension is until the end of June, so until June 30th. So pre-existing appointments have been extended until June 30th. The deadlines for the filing of reports, of GAL reports, have also been extended, and it depends a little bit on the original deadline. So if you have questions, of course, you can reach out to GAL, but if you want to know the general status, you can also send an email to the sessions clerk or the assistant judicial case manager for the judge who ordered the GAL originally. In addition, interviews can be done in person, or you know, if there's a concern, of course, then to be done telephonically or virtually. Okay, so going into the question about co-parenting, and we received many questions that were very similar about how to co-parent during this time when parents are disagreeing on a lot of different issues. First thing I will say is, again, just to reiterate, this is a very general discussion. All of these cases, the analysis and the counsel would be very, very, very fact specific. So how someone should proceed on any of these really 100% depends on the detailed facts of their family or of the procedural history of their case. So I'll discuss generally some of the questions that have come up, and then Cindy will address like what sort of general principles or what options are available to parents. So questions come up around parents not following safety precautions. We're seeing them intentionally in domestic violence cases and unintentionally. And unintentional really is about like one parent still being an essential worker or a frontline worker or working at a grocery store, another parent who's living in a shared rooming house, right, with many tenants in one place, or in a homeless shelter or a DV shelter. We're also hearing health safety concerns for lower income parents who have to take the T or the bus with the child across a city or two cities to get to the pickup and drop off location for the shared parenting schedule. We're also hearing about DV shelter concerns, abusers wanting to know the address of confidential shelters or wanting to modify. Besides the address of confidential shelters, just know that that never has to be disclosed, pretty much. Okay, so that's kind of a rule of thumb that does not have to be disclosed, even under COVID. And then wanting to modify because of the shared living situation, or using COVID as a basis of a concern, saying it's a shared living situation, it's unsafe. Again, Cindy will discuss generally what parents can do in those situations and kind of the guiding principles. It's still really kind of unclear how courts will come down. I personally never want to say to my clients, no, you can't, no, you shouldn't, especially when it comes to like really genuine concerns that they have about their children. So it's really up to them and they have to decide themselves. But it is really kind of an unclear, uncertain time right now with these situations in court. And that's just the reality of it. You know, we're trying to use the best guiding principles that we can to guide us, but some of the things that we think should happen are not happening, and then vice versa. So some things, you know, that families might try to do is try to renegotiate or agree to perhaps increase visitation later if the concern for, you know, exposure to COVID is short-lived. Perhaps promising a more generous summer vacation schedule, or a more flexible summer vacation schedule, because there's no like rigid school schedule right now. If those are workable, that's something that, you know, parents should be trying to do if it's safe. I would also want to know what the specific medical concerns are. Is the other parent in actual quarantine, or was asked to be in quarantine and they're not being in quarantine? Do you have that information? Do they actually have symptoms or fever? Are they exposed to someone that's in quarantine, or exposed to someone who had COVID? And if there's concerns about the child's underlying health concerns, does that child does that health concern, is it well documented? Is it a severe health concern? Is it documented by the pediatrician? So there's lots of facts to consider, and individuals really should be honestly trying to discuss that and trying to discuss that with their advocate and their legal services attorney, and hopefully get referred to them. I'm going to quickly just cover also child support issues that have come up, or questions that have come up. So a couple of questions that have come up are, if the payer lost a job, they got laid off under COVID, do they still have to pay child support? Yes. So if the court order is that they have to pay X number of dollars per week, that's what they have to pay until they file a modification. So if they file a modification and the court agrees and decreases down the child support amount, then it can go back and be granted from the time that the complaint was filed going forward, but it does not, it's not retroactively applied to the time that the job was lost. So it is really important for those parents who are concerned about that to try to file as soon as possible. Also with the understanding that unemployment insurance and pandemic unemployment assistance benefits, which is all the UI benefits, will be factored into the child support if they're receiving it. It is important that even if the job is lost, knowing that the custodial parent probably also lost their job and they're still a child. So try to pay something, any amount, some good faith effort amount if possible, even if the full payment is not possible. And then for the custodial parent on the other side, losing that income, losing the earned income, losing the child support income, it's not okay. There was a question on what to do if courts, if the custodial parent withholds parenting time. Can't do that. Courts are not okay with the custodial parent suspending parenting time for that reason. If the custodial parent is having a hard time with the income, definitely try to connect them with DTA Connect Online, exploring public benefits, SNAP, supplemental SNAP for school-age kids, food pantries, and other COVID-related funds. There was a question on how to collect child support from a parent who's left the country. Unfortunately, it's nearly impossible. The obligation can continue, and the arrears keep collecting, but enforcement is really kind of insurmountable. However, if it is done through DOR, if it's being paid through DOR, DOR reports to the Treasury, reports to the Social Security Administration, Department of State, and so those agencies like the Department of State can refuse to renew that person's passport if they want to renew their US passport. They can intercept tax refunds for child support. SSA can garnish child support for those who are receiving Social Security or SSDI, the disability. And you can apply for DOR enforcement anytime to try to get at it that way, but there's no direct enforcement for that parent who's left the country that's easy or straightforward that I can speak of generally, unfortunately. And then the last question here is, how do child support arrears impact the stimulus rebate? If the payer parent owes more than $150 and the other family's on public benefits, or $500 if his child's family's not on public benefits, then DOR will intercept the economic stimulus payment and use that to help offset and pay the child support. Okay, so the next section, Cindy will discuss sort of what can families do during this time, what are the general or guiding principles, what can parents do with some of these issues?
So this is a really tough situation that everybody is in, no matter what's going on. It's just very difficult, but it's also really, really difficult for parents. And it's hard for advocates as well when you have a parent who says, I'm too afraid to send my child to parenting time. And then you have the other parent who says, I'm so worried about my child, but the other parent isn't letting me see them. So it's really a struggle on both sides. And ultimately, parents have to decide what's best for their child and do that. However, we cannot say that the court is always going to agree with them. And that's what's difficult. And so on the one hand, there is a risk associated with canceling parenting time. And the risk associated is that the other parent files a complaint for contempt. Then the question becomes, how is the court going to view this? And the answer to that, unfortunately, is always, it depends. Because it depends on who the judge is, what is stated in the pleading, what the communication is that's done in the courtroom, etc. It's important to keep a couple of things in mind. A contempt is a willful violation of a clear and unequivocal order. Maybe the part that's being violated is not clear and unequivocal. That's a possibility. The other part is that maybe a judge says they don't see it as willful. If there was a genuine concern, they might not find it to be willful. But what I would try to advise people about or give them information is it's important to put as much in writing as possible so that if this does result in a contempt being filed, that they can show the judge, here are the reasons why I stated I needed to cancel parenting time, and here's what I offered instead, FaceTime or, something. I mean, we're all on a various size screen throughout the day. Maybe it's something like that that was offered. The other part of it is, what about the modification? What if the parent says, I want to go in and file a modification because, the other side is not agreeing, and so we need to go in and modify the order. Again, a modification is a material change in circumstances. What has changed since the date of the last judgment? Obviously, COVID has changed, but is that a temporary change or is that a permanent change? Is it necessary to go in on an emergency basis, or is this something that can wait? It's really hard because the guidance from the court is not specifically clear as to what they view as an emergency, what's not an emergency, when they want you to come in, when you don't have to come in. But the one thing that is clear is that all current court orders are remaining in effect. They're not suspending orders. Those are in place. So then it becomes a balancing act for the parent to decide what they can do. And, it's a really, really tough call for a lot of individuals to be in this situation. Modifications as they relate to child support, as we mentioned earlier, you do want to file those modifications. It's very important that you do that. When it comes to filing contempts and modifications, it can be really difficult if the parties are in a really bad situation where they have no ability to communicate with each other and can't communicate. And I know that from an advocate standpoint, particularly with a surviving client, you don't want to disempower that client, as Simone said, and that can be a really tough call. But I think that it is important to stress that we do not know what judges will do in every case because it is so fact specific. And we're always sharing information with each other about what judges did, and many times surprised in a not good way. So it is just important to know that that is a type of risk. That is everything that I have on contempts and modifications. You can still file them. It's up to a judge to decide whether or not they find somebody in contempt. It's up to a judge to decide whether they think that there is a material change in circumstances that necessitates the modification. And again, it's just really difficult to get clear guidance as to what a judge would do during these times. Everything in family law is so fact specific, and judges have such broad discretion.
Okay, everybody. Thank you so much for sticking around for this whole presentation. We've gotten so much information, and I'm sure that everybody's brain is swimming as mine is. One of the themes I think I noticed from the chat is frustration on feeling like there's not as much concrete things that we can really do to work with survivors to help increase their safety. I don't think that probably would have been much different if we had had this program 6 months ago as it is to now. I think it's just important that we all keep trying to think about this together. And I want to introduce you finally to, sorry?
Jennifer, can I say one thing I forgot to say before Rochelle comes on? Jesse had told you about getting orders in district court, and when you have your hearing after notice, the court can put in an order for a year. But when the courts reopen, the defendant can ask for a hearing. That's actually different in probate and family court. In probate and family court, they give you a short order and they say, when the court's open, you're going to have to come back in and have another hearing. And we don't know what the standard is. So if you have choices between district court and probate and family court, for that reason alone, you might want to go to district court. Sorry, I totally forgot that.
Thanks, Jamie. That was really an important thing to highlight. Okay, without further ado, then I wanted to introduce you all to Rochelle Hahn, who's going to talk us through some of the existing resources, particularly online, that folks can go to get more answers. Rochelle is an attorney with over 30 years of legal aid experience. She currently works at the Mass Law Reform Institute, where she's the co-manager of the Civil Legal Aid for Victims of Crime Initiative, also probably known to many of you as CLAVIC. She's also the co-director of the Massachusetts Legal Aid Websites Project. Thanks, Rochelle.
Rochelle, you're muted.
Sorry about that. Okay, great. Thank you. I got so used to my good Zoom behavior and always keeping myself muted that I forgot to unmute. Anyway, thanks for everyone. Just to let you all know that we will be posting a recording onto Mass Legal Help, and we will share that out, and you can refer to it afterwards, and also feel free to share it with your colleagues. So I'm just going to quickly review some places where you can find some of the information that was shared out today. One of the resources that we encourage people to use is Mass Legal Help. It's masslegalhelp.org. This is a website with a lot of, it's run by the Websites Project on behalf of the legal aid programs in Massachusetts. We take legal information and translate it into English, and as well as other languages, and then post it on the website. And we have a whole section here on COVID-19 related information. So that's, you go to Mass Legal Help on the left-hand side, there's a section for COVID-19. There's a lot of different topics, and as well as the ones we discussed today, like unemployment and housing and information about the eviction moratorium. But we do have information specific to what we talked about today. Here on the left, you see there's a link to restraining orders, and we have a summary about getting a restraining order during this time, including a short video. And we also have a section on courts. Oops, sorry. So the courts, and we have just general information about court hearings, including again a video about courts. And there's also specific information about the probate court. So a lot of the information that was referenced in Kristen's presentation, we also include on Mass Legal Help. In addition, we have links as part of this to the court website itself. The court has a really terrific website about here called the Court System Response to COVID-19. And it's a really great compilation of all sorts of information. As you can see, there's a specific section on domestic violence, which includes links to a number of the forms that someone referred to earlier. We also have here a resource guide that the court developed, the district court in conjunction with MOVA, and this is arranged by county, and it lists different DV and sexual assault counselors and resources in each county. So that's a really useful resource. Also, you can also find from this court section, sorry, going back. Sorry. Cindy had mentioned before how each probate court in particular does things a different way. So from this page, this general court page, there's something about the probate court. And then as part of the probate court, there's the division protocols for each of those courts. So depending on where you live, you could go and see what the particular rules are for that court. So all that information can be found on Mass Legal Help and also the court websites. Now, the other thing is that you may want to, your client is in a situation where they actually need legal representation or either advice or actual full rep. And legal aid is still open and operating. We have been operating all throughout the pandemic, not in person, but people are able to access us virtually and through telephone and through increasingly through online resources. So we have developed something called the Massachusetts Legal Resource Finder, which is a way that you can find out what legal aid program might be able to help your client. So again, from Mass Legal Help on the right-hand side, there's always a link called Find Legal Aid, and that will bring you to the Legal Resource Finder. We encourage people to do a search to find out the most targeted information. So for example, if I am trying to help somebody who lives in Lynn, and I would say, and let's say this is someone that's a household of 2 and the rough income is roughly $500. They're looking for help with a restraining order. They might say they're a survivor of domestic violence and they need help getting a restraining order. And then you click the search button. And these, you get contact information for different entities that might be able to help you with your legal problem. So one of the options here would be Northeast Legal Aid, which is the Civil Legal Aid Program. Veterans Legal Services might be able to help a veteran. Massachusetts Bar Association does monthly call-in sessions, the Women's Bar Foundation. So and then we also include links to legal information. And here in this case, we also have a link to the Safelink hotline. So I do encourage people to take a look at that. If you're not in a position where you're able to actually do an individual search, we do have kind of an overview from this link, legal aid programs. So you could divide that up by, let's say you work in Western Mass and you want to know what kind of family law resources are there. You could filter it, and this tells you some of the various resources that exist to help people in Western Mass. It's not as targeted, but it's still useful for you to get a sense of who's operating in your jurisdiction. One of the statewide programs that does operate throughout the state is CLAVIC, Civil Legal Aid for Victims of Crime. And that is a program that's funded by MOVA. And we provide legal assistance, civil legal aid to victims of crime and also survivors of domestic violence and sexual assault. And we will help them with related legal issues, which could be family law issues, it could be other issues as well. The CLAVIC lawyers are embedded in those local legal aid programs, but you can also find out which CLAVIC program serves your jurisdiction by coming to this CLAVIC website. And it includes all the legal aid programs. It also includes Victim Rights Law Center, which has a particular focus on assisting victims of sexual assault. So another general resource that I just want to flag for people, again, you could find it from Mass Legal Help, is Ask a Law Librarian. You could get to that link on the right-hand side. The law librarians are awesome. They're a fantastic resource, and you can call the law library, you can chat with them, you can email with them, and they will provide you with legal information. They can't represent someone, but they can provide you with legal information, links to statutes, sometimes even provide documents. So I do encourage people to use that law library resource. There's another online resource that you can use, Mass Legal Answers Online. Mass Legal Answers Online is also a website. In this case, your clients can make an account on Mass Legal Answers Online, ask their legal question through the website, and they will get advice from a volunteer lawyer. It's more than information. They'll actually get targeted advice for their situation. So encourage you to use that. And then finally, I want to just make that pitch once again about Safelink. We've shared out that information in a few places, but Safelink is the statewide referral point for domestic violence and sexual assault programs in the state. You can call them. And similarly, Ask MOVA, which is run by the Office for Victim Assistance. Oops, where's the link here? Ask MOVA will also, through Ask MOVA, you can also get links to the Safe Plan advocates, to the other community domestic violence and sexual assault advocates, and also to other resources to help survivors. So I think that's it for me. Thank you.
Wonderful. Thank you so much to everyone who participated. It's a really tough time for all of us, and particularly a thorny time for the family law, domestic violence community, as there are so many new issues sort of coming at us one after the other. We plan on sending out an email to folks who attended. We will be providing access to slides. Rochelle, we volunteered for you in the chat to write up just a little something about the links that you were showing to everybody. Folks seem to find that really, really interesting. So most of all, thank you so much for attending. And we really wish you all the best during this time and hope that you and your clients and your loved ones are safe and healthy. So thank you.
Thank you.